Welcome to the Business Rescue Boardroom. Welcome in the Business Rescue Boardroom. Today we're going to discuss the business rescue process. This is now after the assessment has been done by your lawyer, auditor or business rescue practitioner if your company can go into business rescue. And what then? What must happen? So I will discuss today the board resolution to begin business rescue proceedings. The court order to begin business rescue proceedings is something that will follow the same process, but for the fact that the court ordered that the entity goes into business rescue. So when your board resolution is taken, there's some documentation that must be lodged with the CIPC, and the CIPC has 5 days to do their administration. You have to announce your business rescue to the affected persons, being the creditors, the employees, and also the shareholders of the company. That you have to announce that you're now in business rescue within 5 business days after the board resolution has been filed with the CIPC. Now, then the business rescue practitioner is appointed in the same 5 days, and he has full management control of your company. Understand that the business rescue practitioner is actually the super CEO of your company. He's driving the business rescue process. You, as the owner of the company and the management of the company, will surely get a delegation of powers from the business rescue practitioner to carry on with your day-to-day business of the company as such. The business rescue practitioner, however, have a few statutory obligations to follow. And there are some time frames that I will discuss with you now. Within 10 business days, the business rescue practitioner must convene a meeting and preside over a meeting of creditors and also over a meeting of employees. That's in terms of Section 147 and 148 of the Companies Act. At that meeting, he have to convey the message to the creditors if he thinks there is a reasonable prospect of rescuing the business. For the employees, they must do the same. He must then, if he believes, actually the word's not think, the word choice of the legislator is believe that there is a reasonable prospect of rescuing the business. He may entertain some questions, may accept claims, and also you as a creditor or the creditors or the employees may have a creditors committee or employees committee. Then the real fun begins. If as I've said in the previous boardroom meeting, we have a moratorium on legal actions, but the creditors by this time are very upset with the company. They're trying to collect the vehicles that's under hire purchase. The employees found out that the Provident Fund and the medical fund wasn't paid. Then you inundated with phone calls. Now this is in the life of the business rescue practitioner. But in the meantime, he have to investigate the affairs of the company. There's some practical situations that occurs, which Gideon will discuss with you in a few minutes. But then after the first meeting of creditors and the first meeting of employees, you've got 15 business days as business rescue practitioner to publish a business rescue plan that contains some information about the background of the company, what arrangement would like to have with the creditors, and what the influence that will have on the company's liquidity and solvency going forward. After you publish the business rescue plan, 10 days after that, you have to have a second meeting of creditors, and at that meeting, creditors must vote in favor or against the plan. It's not a number of creditors, but value of the claim that votes, and 75% of the value of the independent creditors must vote in favor of the plan. That is in a nutshell the process that must be followed. Gideon, in the real life world, there is certain things that happens after the appointment in regard to the bank account and other stuff. Can you just brief us on that, please?
Thank you, George. I think quite often the first 10 days of a business rescue is extremely dynamic, but also generic, or the play of events happen or occur in every business rescue. So practitioners are independent to the business. They might have done an assessment of the business, but they have not really dived into the detail of what is really going on into the business. Once you filed for business rescue, the first action is to notify the creditors or all the affected parties. As George mentioned previously, the affected parties of a business rescue is all parties that is owed money, and this would include employees if there were unpaid salaries before the commencement of business rescue proceedings, any creditors, and then any financiers to the business, and directors and shareholders as well could be affected parties to the business rescue. Secondly, once you have notified the affected parties, that is the period when you'll get response. The banks usually find out about the business rescue automatically. Once the status with the CIPC has changed, the company is flagged with the bank, and then the whole rescue process or the whole account of the commercial banking moves to the recoveries division. Every bank has got a recoveries division where a specialist then engages with the business rescue practitioner. During this phase is when the business rescue practitioner needs to engage with the bank recovery specialist, which then also negotiates the security of the company. In a lot of instances, or in most cases, companies have got overdraft facilities, and the bank needs to understand how they would be protected during the business rescue process if they support the business rescue. Usually they are secured with cession of debtors or possibly personal sureties, or they've got security over other assets of the company. If you've got a reputable business rescue practitioner, the banks and the financing institutions are usually comfortable to proceed with the business rescue proceedings and to see the process through. Thirdly is the creditors. Usually the company does not know what was signed or agreed to originally in the credit terms of the company, and this would mean that the company would need to provide the practitioner with this information so that the practitioner can determine what is the financial stance. Is there sureties against the business? Is there sureties against directors? Or is there personal sureties against the shareholder? And this is usually important as it further down in the process defines how the business rescue practitioner can rank the credit, the dividends or proceeds that is assigned to each creditor. During the second phase after the notification of the practitioner is the creditors meeting, and this is usually a meeting for all affected parties whereby the business rescue practitioner is introduced, and the practitioner also describes or explains the process to the affected parties present. Usually not all affected parties pitch for such a meeting, but it is recommended that all affected parties engage from day one with the business rescue practitioner as important information of the process is divulged. During this first 10 days, the business rescue practitioner needs to establish the position of the company, and usually the practitioner is challenged because all the information is not necessarily available. So the practitioner needs to condense or do a super analysis within the first 10 days so that he can advise on the first creditors meeting if there is reasonable prospect or not. Thereafter, the first meeting will be adjourned, and then the practitioner will have the opportunity to implement turnaround strategy and to further assess the business and also develop the business rescue plan. The Act calls for 25 days that has to endure so that the business rescue practitioner can publish the plan. In my experience, this is extreme tight deadline for a business rescue practitioner as you are dealing with very dynamic specifics in your business rescue. And on the first meeting, the practitioner will usually communicate how long or when does he plan to publish the business rescue plan.
Yes, thank you for that explanation, Gideon. In my experience, sometimes the bank stop the account and you have to negotiate with it. And the other thing is you have to have a working relationship with your board of directors and management. It is a stressful situation. The board is, or all of the board members or management aren't too happy about the decision to go into business rescue. Maybe they wanted another business rescue practitioner. And the main goal is to rescue the business. I also usually say, if you're a friend of the company, you're a friend of the business rescue practitioner. If you're an enemy of the company by trying to take some of the assets away or trying to hide some information, then you're an enemy of the company and you don't want the business rescue to proceed, and you rather than leave the business rescue process as a manager or something like that, and we will work with the people that wants to rescue the business, and hopefully the creditors and the employees wants the business to be successful. Next time in the Business Rescue Boardroom, we will have a guest in the form of Professor Andre Berein from Tukkies, who is a specialist in business rescue and insolvency law. Thank you for attending the meeting in the boardroom.